ceiling, so that's a good starting point. So a couple of preliminary things. Firstly, if there's anybody who wasn't here last week, I've still got some of the one-page handout I gave out describing the same figures available on Keys. I'm happy to give out copies. How many people? Okay. Sorry, do you mind if you give me a hand in the air? Okay. Next, an apology. I am told that the lecture capture did not work last week. Red normally means good. Red means it's working, or at least it always has in the past. The only explanation I've had so far is that there were technical issues and they were being looked at. And I said, well, that's very nice. Please can they be looked at by next week? Haven't heard back on that, but hopefully all is well. I don't need all of you to tell me if it's not, but please can somebody tell me if there's a problem, and I will obviously investigate again. The reality is that was an introductory seminar, and I have basically outlined the course material what we're doing, and today is an introductory debate, so hopefully not too much is lost, but it shouldn't happen, and although it's not completely my gift, I hope it won't happen again. Next, how have people got on in terms of finding this book? Have you been able to get hold of it? Some in the post, some in the book. Not to worry too much. As I say, from next week we will be looking at it. It's not the end of the world if you have to rearrange yourself for a class or two to share with a kind neighbour, but you will need to get hold of a copy of Hartley. Anyone else who has any questions about the course, particularly those who weren't here last week, but anybody, I will happily take those at the end of the day. But let's try and move on a little bit. So today, as advertised, really, I just want to have a discussion with you with not a particularly fixed agenda, and I think we should get into some of the topics we're going to be talking about later in the course, and use it as a discussion. As I say, these seminars will be very boring for everybody if all I do is talk to you for 2 hours, and in fact I've got no intention of doing it anyway. So please do put forward your views. But we've got to start somewhere. So I'm going to suggest that we start here. One of the things I said about this branch of the law of jurisdiction, international jurisdiction, and the law of enforcing foreign judgments, is, and I said this last week, is that it forms part of the branch of the law known as private international law. Or the alternative name, which is used particularly in my experience in common law legal systems, also the alternative name for the subject. Sometimes conflict of laws is the whole, choice of law is part of it, but conflict of laws is the whole subject. Now, really, certainly in this country, those two names are used completely interchangeably, and it doesn't really matter which one you do use to describe the subject of resolving matters, cross-border matters. Just to add to the fun, some of you may know in Scotland they call it international private law. Just to add another name into the mix. No one says who cares, it doesn't matter. In another sense, I think it does reveal something, which is this is quite a difficult area of law to pin down in terms of where it fits into the categorisation of different areas of law. It's quite easy to categorise things like contract or tort or property or criminal law. And this area of the law is slightly more elusive. Let's start here. If you think about areas of law, it doesn't really matter probably really what legal system you've studied before. You can think of two types of areas of law, very broadly speaking. You've got the branches of domestic law that each country in the world has. So I'm talking about areas like contract law. some legal systems don't. Property law. Obvious things like this. Now the point about all of those areas of the law is, every legal system in the world has them, but they may or may not be. They may have been copied or adapted or adopted elsewhere in the world. But there's no reason why, for example, English contract law should be the same as Brazilian contract law, because each legal system develops its own set of rules to deal with that branch of the law. That's what I mean by calling it a branch of domestic law. Now, in some areas, not that many actually, but in some bits of, for example, contract law, the problem that every country has its own laws has been dealt with by agreeing, on the world scale, international conventions. Many of you may, for example, know about the Vienna Convention on International Sale of Goods, which is one example of a way of bringing together different legal systems so that they agree to have the same area of rules of law in that area. Because in the absence of a convention, they don't. A different kind of harmonisation obviously occurs in the European Union, where, for example, the member states have agreed rules, for example, on unfair terms in consumer contracts, for example. But the point is, it requires, absent some kind of international cooperation to agree to have the same rules. Every legal system will have its own rules. Now, if you think about that, on the one hand, what is different? I've looked at these private international ones. What's different between those categories and, for example, it doesn't really matter whether you go into detail or not, public international law, the law of war and peace, the law of who owns the seabed and territorial waters and airspace. What's different between that branch of the law on the one hand and, for example, contract law and property law on the other? Yeah.
Parties involved?
Yes, certainly. In what sense?
So, public international law gives you state to state.
Yes.
And private international law gives you individuals.
Okay. Might be one state and one individual in public international law, but certainly there is, by definition, likely to be some public body involved completely. But I'm thinking a different point, really. In terms of this category of domestic law, every legal system has its own rules, and they may or may not be the same as the next country. Is public international law of that nature? How's it different?
It's public international law is, for example, what you see or so it's one set or a couple of treaties or conventions that are mostly each rather than individual to each state.
Exactly right, what you can say.
It's based on consent, there's no worlds of governments to say.
Okay, but we agree that it's based on a set of consent. Yes, consent, but a set of rules that countries, by definition, share. Otherwise, it doesn't work. Okay. So we could put public international law back up here and say it's not the kind of law, same kind of law at all, because it's not internal to different legal systems. It's a common set of norms that are applicable in all states. Okay. Perhaps we could use this phrase, perhaps we could call them supranational rules. The whole point of them is that the UK can't have its own rules on who owns the seabed and then find that France disagrees with it and that the same stretch of sea, the channel between the UK and France, that the UK and France have different views about who owns what. Same with the law of war and peace. They have to be an internationally agreed set of norms which are common to the world. Okay, some people breach them, but the standards themselves are world supranational standards. Come back to the subject we're looking at in this course, private international law. And let's answer this question. Where does private international law best fit? If you were taking it, sticking it, and then sticking it on this board, where would you be most inclined to stick it? Up here, as a kind of supranational law that sits above that of individual legal systems, or as a branch of domestic law of each and every country? Where's it best belong on that diagram? Where's private international best belong? Yeah.
Rather a branch of domestic law. So the states themselves define when they are competent for the case.
That's exactly right. So the oddity about private international law is that its relationship with public international law, although a complex one, can be very misleading. Because private international law is quite emphatically, although it's obviously about what to do with cross-border disputes, international disputes, its place in a kind of taxonomy is quite definitely down here. It is a branch of domestic law. In each and every country of the world. It's what the English courts do when they are faced with a cross-border dispute. What the Texan courts do when they are faced with a cross-border dispute. What the Chinese courts do when they are faced with a cross-border dispute. And there is no internationally agreed rule about what to do in those situations. So quite rightly, as you say, I mean, in one sense, private international law is more private than it is international in one sort of classification sort of sense of the law. It is a branch of the law of each country. Now, what's the implication of that? Supposing that two parties enter into a contract, and one of the parties is X is from England, and the other party to the contract is from, let's say, Texas. And a dispute arises between them. X says, when these goods were delivered to me, they weren't satisfactory quality, and wants to sue to get a replacement. The seller to get a replacement. Y says, there was nothing wrong with those goods, you haven't paid for them on time, I'm going to sue you for the purchase price. So we've got a situation here where either party potentially might want to sue the other from a fairly typical set of facts where there's a disagreement about the quality of goods provided. And the English courts will clearly have to take their own view about whether they should hear this dispute or not if, for example, X decides that he or she wants to sue Y in the English courts. The English court will have to have conflict of law rules to decide whether they'll hear that dispute or not. Whatever the answer to that question is, what is the implication? Supposing it's Y, and Y being a Texan, remember Y was the seller in my example, who hasn't been paid, is pretty angry. Y being a Texan, all things being equal, is probably going to want to sue in Texas, because we'll talk about this a bit later, but people, all things being equal, tend to want to sue at home. The obvious convenience and familiarity. There's no great surprise to see that. So Y might want to bring proceedings in Texas. X might want to bring proceedings arising out of this contract in England. What's the problem that you highlighted a minute ago about private international law belonging down here rather than up here? What could happen in this matter? If X tries to go before the English courts to sue and Y tries to go before the Texan courts to sue, what might happen?
Both or neither courts refuse jurisdiction.
Exactly so. They're each going to apply their own domestic bit of law that is private international law, and they're each going to reach their own view about whether they're prepared to hear the dispute or not. Which, as you say, could lead to the conclusion that although the only connection that this contract has is the two countries, legal systems, England and Texas, that neither of them is willing to hear the case. But experience tells you that most courts are quite greedy when it comes to jurisdiction, and actually it's more likely the other problem you identified, that they both think and are both adamantly believe that they are right, and no doubt believe they are the only right place where a dispute about this contract should be. Let me put it another way to you. Conflict of laws, when you think about it in the first for a few seconds, you kind of know what that's about in England. It's saying, oh, well, two legal systems collide. In this example, England and Texas. And it's about the English court saying, well, what do they do when those two legal systems collide? Should they be prepared to entertain dispute? Should they not be prepared to entertain dispute? So there certainly is that conflict in the English courts, what to do when two different legal systems collide. But another way of looking at it is that there are actually, what makes this subject so interesting, I think, is because this subject isn't just private, it is international, these are cross-border matters. Other legal systems are going to have their own views about what should happen with this kind of dispute that touches and concerns them as well. And if you think about it, it's not just the internal conflict, what should an English court do about this dispute, there's a double conflict going on. Because whatever the English court's answer to that question, other legal systems are going to have their own answers to the same question, and they may be completely inconsistent with each other. And the most unseemly, but also the most common example, is where they both think that the case should be heard and only should be heard in their courts. That is, I think, precisely what makes private international law so interesting, because these kind of problems are, in one sense, private problems, but in another sense are very international problems, because, as a matter of fact, English courts don't want to go trampling over relations with friendly foreign countries by taking cases that, frankly, don't really belong in the English courts and hearing those disputes. We'll talk about more about that in a few minutes. Now, against that background, I'm sure you can see that very early on in the life, well, pretty early on anyway, in the life of the European Union, the European community as it was, it was realised very early on that this just wouldn't do in a European system. In a European system which was premised on the idea of trusting and respecting and enabling free and easy recovery of contractual and other debts from parties in the rest of the European Union. So very early on in the life of the European community, a project was conceived to say, well, hang on a minute, this is too problematic. We don't want the courts of, for example, to take the founder member states, we don't want the courts of, for example, France and Italy squabbling with each other about whether a dispute belongs in one court or the other court. And that was the inspiration as long ago as 1968 for the original so-called Brussels Convention in the European community, which initially was between, when there were 28 now, but 6 countries in the European community back then, to agree a convention to harmonise the rules of jurisdiction so that basically all, for matters within its scope, and we'll talk about that a little bit later, all of the European community countries would have the same rules of jurisdiction to try and prevent exactly this kind of squabble between those countries. And in a way, the Brussels Convention, the original Brussels Convention of 1968, which harmonised all the rules of jurisdiction within its scope in the European community, has been there ever since. And as of today, and more on this in weeks to come, it has been expanded its scope. Today it has the not necessarily particularly exciting title of the Recast Judgments Regulation of 2012, although confusingly didn't enter into force in its latest version until the 10th of January 2015. But you get the idea immediately of why it's a good idea to have the same rules of jurisdiction if you can around the European Union. And we'll come back and talk a little bit more about that in a moment. But apart from very, very limited initiatives outside the European Union, there is still very, very little global level harmonisation of the rules of international jurisdiction, particular, for example, there's no harmonisation between the UK and the United States, China, Brazil, India, Russia. I could go on. So, although the European Union is a special case, the rest of the world is a more typical case, actually, where there is very, very limited global harmonisation, and therefore these double conflicts arise a great deal. Much more on that to come. Who would you say, if you're talking about a cross-border matter, a cross-border potential dispute between a claimant and somebody who's threatening to sue somebody else, let's say for money that they say is due under a contract, and the defendant is saying, no, I don't want you, I've got a perfectly good defence. If you sue me, I'm going to defend the case, and so on and so forth. Who has, as a starting point, would you say, most of the power in that relationship in terms of bringing a cross-border dispute? Claimant or the defendant?
I think defendant.
Why?
They might still be getting cross.
Yeah.
Actually. So it's just natural as it's not usually.
Okay. So the claimant is certainly going to have the onus of doing something, otherwise they're not going to get any money. And in that sense, the initial burden is on the claimant. But once the claimant says, yes, I've got the money, I'm going to do it, I'm going to sue, and it's an international case, what advantages does the claimant have? Yeah. Okay. They get to pick where. Potentially, imagine the situation we talked about a few minutes ago, where, for example, the dispute, could potentially be brought in England or could be brought in Texas. It's the claimant that will decide which one. Yeah, sorry.
I don't really think that the advantages of the claimant. I think the advantages of the defendant.
Why is that?
Because the claimant will choose a jurisdiction where you will file the suit, connecting the jurisdiction to the course of action or his claim, but the defendant will have the advantage that if there's no connection between him or he does not consent, we will certainly put to distress the claimant.
Okay, and that's true enough. I'll come to that point in a moment. But I think it is true to say that the claimant holds the initial advantages, because the claimant in this situation, for example, where potentially you could bring the claim in either the Texas or English courts, then either of them will be willing to hear the case. It's the claimant that decides whether to bring the case. It's the claimant that decides exactly when to bring the case. And above all, it's the claimant that decides whether, when, but above all, where to bring the case. And you could imagine if the facts are more complicated and there are connections to 3, 4, 5 different countries, there may be a suite of options available to the claimant in terms of where to sue. And the poor old defendant can't really, or at least can't initially, and I take the point you make, can't initially, let's put it that way, do anything about that choice, because the claimant will make that choice, and the defendant will be, by definition, having to respond to whatever choice the claimant has made. So the advantages of the claimant, I think, initially, are magnified in cross-border litigation compared to domestic litigation because of this option of looking around the world and picking a place that they want to sue. And there's a nice term that you may have read in the books for that art of looking around the world as a claimant and picking the place where you'd most like to sue. What's that sometimes called? That's sometimes called forum shopping. The quaint phrase, and it's obvious what it means. I think initially it's not one of those complicated terms. And that's what it means. Picking the place that would be most suitable for you to start your claim. And we'll talk about forum shopping a bit more in a few minutes. Now, it is definitely true to say, what you say is definitely true. Making a rash choice of forum as a claimant, because, for example, you think you'll get more money there, is a very easy thing to do to start off, and a very easy thing to end up regretting if the defendant takes issue with the fact that the proceedings have started there, and successfully persuades the judge that the proceedings should not have been started there and that the judge should not hear the case, then the proceedings will probably be dismissed. And if you're talking about in England at least, if the claimant brings proceedings in England and the judge eventually decides that he or she is not prepared to hear the case or can't hear the case, then you are likely to be looking at a very substantial cost order being made against you as a claimant for having brought proceedings in England when you shouldn't. Let me tell you that in my experience in the commercial court in London, it is rare for the costs of a jurisdiction challenge, if you're talking about both sides' costs, to come in up below, say, £150,000. And often it's double or triple that in cost. So if you're paying all your own costs, because you won't get the back if you started proceedings here and you shouldn't have done, and you end up paying all the defendant's costs because the defendant convinces the judge that the case should never be brought here, that's a tremendously expensive mistake. So you're right, you're right, and you're all right that this is not a one-sided process. The defendant can always argue to the court that this case should not be heard. And it doesn't really matter what system you're talking about. It's common to refer to that as a jurisdiction challenge by the defendant, and it's obvious what that means. The claim started here, the defendant says, shouldn't be heard. You're right about that. But personally, I still do think that the claim holds the greater advantage because of that ability to pick the forum, timing of the case, and to pick around the world from a suite of options. I do think that gives the claimant an inherent advantage. And because, as we've already said, unless there's a really good reason, there are good reasons to go elsewhere, many claimants prefer to choose their home country in which to sue, which kind of stands to reason. In a genuinely cross-border case, that is equally going to be a very unfavourable result for the defendant because it's likely to be not the defendant's home country by definition if the claimant is English. And anybody at the top of these diagrams, or we use it throughout the courses, tend to be a claimant, and anyone at the bottom of the defendant. The claimant, the English defendant, is suing a Texas defendant, then the defendant is facing proceedings away from home, as it were. We'll come back to that idea, I think, in a few minutes. Let's talk about forum shopping a little bit more. If you're a claimant, what things might, just think about it, what sort of things might influence your decision in terms of where to shop? Which country to go for? What sort of things? Yeah. Okay. Actually, you haven't mentioned the most obvious one that we talked about, so let's put the most obvious one at the beginning. The most obvious one is pure convenience, the advantage of suing at home. Second on the list is probably damages. In what sense? What sort of things attract people?
The jurisdiction that is more given to give more amount of damages.
Okay. Can you think of any jurisdictions that might be particularly enticing? Yeah.
Well, I think that is because of the situation about the defendant or defendant's assets.
Okay, that's another point. I'll come back to that point, and I'll put it on the board so that I don't forget it. But just in terms of damages, where might be, do you think, an attractive place for a lot of litigants to sue? Yeah. You will be struck, I think, as we go through this course, by how many people, often English people, try to sue in one particular state. You might think it would be somewhere like Delaware that has lower regulation, but it's actually Texas. Person after person in these cases has been lured to go to Texas. What kind of damages are we talking about? What phenomenon? Yeah. Okay. Partly jury trials, and all the, as I said last week, all the empirical evidence is that they tend to award much higher damages than a judge. And except in defamation cases, for example, in England, you would always get a judge, not a jury, deciding a civil trial. What else do they tend to have? Yeah. It's punitive damages. No more so in their famous antitrust law, which In other words, their competition law have particularly famous but it tends to be a combination in the US of those two things, I think. Juries and penal damages. To be honest, not as many, you only have to look at the cases to see how many international companies and oligarchs choose to sue in London, and there are various reasons why they do that. But not many of them are actually doing that, in my experience, because they think they're going to get much more money. Some of them they are because they think they're not going to win at all, or overseas are not going to get a fair trial. But it tends to be the ones who are going to the United States that are more obviously after higher damages when they possibly could win it somewhere else. And I think in saying that, I've just given away another rather obvious reason: is the result. You might not be capable. You might not win in a foreign court, and you might have a chance of winning in another court. What else?
Litigation costs.
What do you mean by that?
Expenses of the attorneys. If there's special fees to pay to the court, or if you can recover expenses if you win the case.
Okay, I'm glad you added the last one, because what I was about to say to you was there are two different points in that. And actually they are almost different points. The first one is the sheer question of how much the lawyers cost, how much it's going to cost to bring a claim in the court. Now let me tell you that by any measure, London does very, very well. By good for lawyers, not so good for anyone else. I mean, London, I don't have the data to make sweeping generalisations, but I don't know of too many legal systems that I've covered where I could hand on heart say that the litigation costs are likely to be higher than they are in London. London, or at least on any measure, would be very, very high up at a global list. Not many people are attracted, let's say, apart from perhaps in different kinds of cases, which we'll talk about, where you can get public funding for people who really don't have any means. Not many people are tempted by the bright lights of suing in London because they think it's going to be cheap. Reassuringly expensive is what we try to sell to the public. It costs a lot, but it's worth it. But the second point is tremendously important. I've already mentioned it today. Does anyone know what happens? I've already mentioned it. What happens in the UK if you bring your claim in the English courts, and you win a trial? What's likely? It won't always happen in the court. What's most likely to happen?
You mean about the costs?
Yeah.
I think the losing party pays.
Yeah, I mean, there's a wide judicial discretion. You don't never, in my experience, get anything like 100% of all your costs once they're assessed in detail. But it will do for today that, broadly speaking, in most cases, if you win, you not only get your costs, but you get your costs are recoverable from the other side. So if the defendant loses, the defendant's going to pay all of the defendant's own legal costs, obviously, and they're going to pay all the claimants. That is a significant draw of suing in London. Because again, generalising that we'll do today for about 50 US states in one breath. What is the general rule in the United States? Yeah.
They are divided.
They are divided. In many states they are unrecoverable. They are simply unrecoverable costs. You pay your own costs and that's it, whether you win or lose. But let's not shy away from this. That means that the stakes in international litigation in England and all places are huge. It's brilliant to say if you win, you'll have brought all these proceedings and you'll have got most of your costs back. But the other side of that coin is what? The number of people who start litigation and end up going bankrupt, and I'm talking about quite sizable companies as well, not just individuals, is quite significant. Good news for you, I know I sound tremendously cynical, but it's true. A lot of people fight the jurisdiction battle in England tooth and nail, as hard as they can, because it's the first big battle. It's shorter, but it's still usually 1 or 2 days at least in court. And they fight as hard as they can, and then suddenly one side loses. and they think, oh, well, I'm now facing a trial, if it's the defendant, I'm now facing a trial in London. And I've got this horrendous cost order, and we've only dealt with jurisdiction so far. I'm $500,000 down, 250 on my own lawyers and 250,000 on the other side's lawyers. An enormous number of cases fight really hard all the way up jurisdiction and then settle really, really quickly once the English court has decided it's going to keep the case. Or indeed, from the other point of view, once the English court has decided it's not going to keep the case and the claimant's faced with starting all over again in a different forum. Okay? But certainly that recoverability of costs from the other side is a huge factor. What else? There's another big reason why people write in the United States.
Evidence.
Yeah, go on. Give us a
Discovery.
Yeah. Tell me.
In the United States, there's rules about discovery that you can ask for all for the evidence that the party has, such as in other jurisdictions. It's not like that. Discovery doesn't exist.
Okay, discovery is a huge factor, I think, in the US. One of the cardinal rules, exceptions to every rule, but we'll do tonight. One of the exceptions to one of the basic rules in English procedural law is that before you start a claim, you can't say to the other side, show me what documents you've got, because I don't really like to bolster my claim a bit, or indeed, if you really don't have a claim, if I'm wrong, show me I'm wrong, show me that you're not liable. Because the general principle is that you have to plead out your claim. You have to plead out your claim based on what you believe professionally is a defensible statement of what has actually happened. And then, and only then, can, if the court decides, if there's no jurisdiction challenge or the case otherwise goes to trial, because the court dismisses the jurisdiction challenge, then and only then are you entitled to ask the other side to disclose all the documents they have that are relevant to the claim. Whereas in the United States, there is, as you know, a much broader concept of asking for documents before you even start your claim. Sometimes, perhaps rather unfairly, described in the English case law as fishing expeditions. Just going out there, trying to see what evidence there might be out there to see whether you can build a case or not. But there's no doubt that it's a huge law. Another huge law for the United States is the rules on discovery. Again, English law probably sits somewhere in the middle. You do have to disclose every single relevant document to the other side's claim or to your own defence. You do have to disclose everything once the claim is launched that's relevant to the claim. But you don't get free trial discussion. What else? Yeah. Okay. I was going to ask you this question. Why do you think, for example, so many cases involving, Hollywood celebrities or Russian oligarchs have been had in the English courts? It's probably not anything to do with anything about this, but in a lot of cases, it is exactly that, a neutral forum, which is extremely highly respected. A lot of these people aren't really actually primarily after the money at all. They're after a judgment from a highly representative court that vindicates their reputation, which they can probably, even if whether it's technically enforceable in the rest of the world or not, it's not really the point. They just want English court, all over the press. English court has ruled X. So there's a mixture of things: technical ability, independence, reputation. They're all sort of in the same family, I think, of issues. I think we've seen quite recently, for example, the completely different way that English judges are appointed compared to, for example, judges in the United States of America. Not commenting on that favourably or unfavourably, but it's certainly true in the United Kingdom that there is zero political process involved in appointment judges. There's an independent commission, and that independent commission selects judges with a competition that they all have to do, and choose the best ones on merit. They're different systems, but it's very difficult to say that the English, not many people argue that the English judicial process is inherently political in any way, shape, or form. And there are different views about that. Can I say, I would appreciate, I'm not going to name it anybody, it would be more helpful for the purpose of these classes, and I will reiterate this feature, if folks were to be turned off so that I have all of them and divided attention. I'd be grateful if everybody could follow that rule, myself included. Thank you. So these are all reasons why you might want to forum shop in England. The only one, that I said I'll come back to and I've forgotten to, is assets. What did you say about assets?
Perhaps it's a multi-international company and there's different subsidiaries. And sometimes the assets may not be in the same jurisdiction.
What's the practical problem? If you see me in England and all of my money is sitting in a bank account in an offshore jurisdiction, what's the practical problem for you? Yeah, you're going to have to go and get that judgment. Well, not necessarily, I might pay, but I'm not going to. You're going to have to go chasing. You've got one judgment, but then you're going to have to go to another. We'll talk about that. Like, go to another legal system and say, "Here's my judgment." Say, please take some notice of it. So, location of assets. But what's the practical problem, particularly with very sophisticated defendants, in relation to assets? The more sophisticated they are, in my experience, the harder it is to predict where they've actually got assets. And the more likely they are to have it through an incredibly elaborate structure, often with multiple holding companies. Sometimes I see 7, 8, 9 holding companies, all in different jurisdictions. The whole point, well, no, I shouldn't say that, it's not fair, but one of the points, arguably, is to make enforcement against those assets quite difficult. It's not always that simple. One of the unfairnesses of life is the deeper the pockets, the easier it is to hide money. For Roger money. As a general rule, but you're right, the protection of assets is one consideration. Certainly less of a consideration in the European Union, because the recast judgments regulation has a very, very liberal set of rules about circulation of judgments around the European Union. But in the rest of the world, there is, minimal global international conventions. There are some, but not very many, about free circulation of judgment. So again, much bigger issue outside of the European, in terms of what we might see from outside of the European Union than it is inside the European Union. Do you think forum shopping, it kind of sounds pejorative. Do you think forum shopping is a bad thing? Answer that question how you liberally think it. But I welcome some views. Who thinks that forum shopping is intrinsically a negative thing? Who doesn't? Any views?
I'd say no.
Why?
If you're looking at it as two commercial parties that something's gone wrong, it's totally natural for those two commercial parties to approach the jurisdiction question by having a look at, like, reasons of practicality, efficiency, those sorts of things, when they're deciding which forum to sue. So if you're faced with a situation where there's one court list that you're familiar with, sufficient.
So from the defendant's point of view, you wouldn't be surprised if you're about to start saying this, you don't think there's anything unfair. What about if you were going to be the defendant?
If there's absolutely no connection, obviously, then that's where it gets to be unfair. But otherwise, if you're coming from the position that the defendants, if there isn't any connection, then they can challenge jurisdiction. So.
Okay. What about the courts? Shouldn't the English court be encouraged or discouraged? Sorry.
I was going to say it's either intrinsically good or bad as the intent behind it. It would be hard to argue that it's intrinsically bad to have the English claimant sue in Texas because that's where the company is and that's where its assets are, and therefore it doesn't have to go through foreign enforcement. That doesn't seem intrinsically bad whatsoever. But if they're suing in Texas because they think they get a big payout as punitive damages, then one could argue that's intrinsically bad because they're foreign shopping profit as opposed to.
And that must be right. One example that I should have mentioned, to take an extreme example, is all the events occurred in a foreign country, but for example, you're not going to get a fair trial in that country. So again, there are examples where you can't possibly criticise. What do you think from the English court's point of view? Or should English courts be encouraging or discouraging this sort of thing? Sorry.
But isn't it more dependent on resources and priorities?
It is, and we'll perhaps talk about that in a minute. Letting anybody, wide open rules of jurisdiction quickly creates practical problems for a court in terms of managing its list of cases. But let me be completely cynical and honest about this. If English law and English courts were too ruthless at telling people, no, sorry, you don't have enough connection in England, off you go, you can't sue here, it would be terrible for lawyers, for legal services in this country. It would be terrible for business probably generally in this country, and there would be an element of sort of shooting yourselves in the foot, because there'll be quite quickly be another country which is prepared to offer those legal services and those wide areas of jurisdiction. Let me tell you immediately that there are already many countries in continental Europe, and I've seen it firsthand. People immediately trying to take advantage of Brexit and the perceived risk that people may not want to litigate as much in England. I've been to events, presentations, all sorts of things. From French lawyers, from Irish lawyers, from Dutch lawyers, from German lawyers. They see a market for legal services. They see that the biggest market for legal services is London at the moment, and they want more of it. Okay? So, there is a balance, clearly, to be struck along the way. Picking up the point that you were just talking about, obviously the English court can't let anyone sue here. We started, you just mentioned practical problems. What sort of practical problems would exist if English law is too liberal in terms of when you can sue them? What kind of problems are you going to get?
Do you think that this is the country of trial?
Okay. Practical problems of getting people here, and not just getting people here, Okay, that's the second point. Another second very, very important point. Somebody else give the evidence here. Now, you might think in this day and age it's difficult to get evidence here. If the evidence is emails or whatever, it's not difficult at all. If, to take one famous case that you'll see later in the term, the case concerns a party going on holiday and being involved in a diving accident on a beach, where the essential allegation is that there weren't sufficient warnings, then the only real way to investigate the evidence is to have a site visit to the beach. In that case, it was in Jamaica. It might not be any great hardship for an English judge, but still, you get the practical point. So certainly problems of evidence if English courts are too wide open. The point that you made, the problems of waiting lists, by definition, if English courts take too many cases that are multi-international, the waiting list is going to affect everyone, including those court cases, which obviously belong in the English court. So all going to be pushed back. Waiting lists they actually vary quite a lot from year to year, but they're not great. I wouldn't say they're, you will have your own views about other legal systems you're familiar with. They're not brilliant in the English court. To bring a jurisdiction challenge in the commercial court that's going to last 2 days, if I rang up tomorrow and said I wanted to get this 2-day jurisdiction challenge listed, I would not be massively confident that the answer would be that I'd get 2 days before April, May. It might be worse. Okay. If I said I've got a 2-week trial to be listed, I wouldn't be massively confident of getting it within 12 months. And it could be 2 years, in the worst case. So, now, I know there's better, I know there's worse. What tends to be better in England is that you will get on an appeal quicker than in my experience. You will often get on within a year, 18 months to be outside in the Court of Appeal, even the Supreme Court. But they're sort of so-so. But there's no doubt that if you stuff your courts full of any case that comes to it, the courts are publicly resourced, unlike most lawyers, and there is only so much money to go round in the legal system. And it's not one of the easiest political causes to sell, that there should be more money for the court, more public money for the courts, as opposed to all the various legal services, as opposed to any various other taxing and spending priorities that there might be in the English court. You mentioned assets being somewhere else. The more cases the English courts take which have very little to do with England, the more likely it is that you're going to have to take the judgment with you and go and try and enforce it in somewhere where the defendant's got assets. What's also more likely is English courts are taking jurisdiction over cases that don't have much to do with them. Maybe that, but in any event, if you go to another country and say, I've got this English judgment, please enforce it, what is the risk that the answer will be? Yeah, we're not going to enforce it. It should never have been heard by the English courts in the first place. That's dispute. So risking self-defeating, because you end up with judgments that are unenforceable in the places where you're actually trying to go after the assets. What else? Yeah.
I think when you go to point of view, in that country, if you have issues with English courts taking on other cases, that they feel they are pursued.
Yeah.
Whether these cases concern international or police issues, that's in that country.
Yes.
In case against the country or the country.
Yes. And if I may broaden that point a bit, you are going to start really upsetting foreign courts if you start taking cases that don't really have much to do with you or much more obviously below in another jurisdiction, because as we said at the start of today, going back to our simple case, if these facts are overwhelmingly connected with Texas, for example, then the Texan courts you may be deciding, as you say, sensitive questions of Texan law, but you may just be really annoying the Texan judge who says, what is this case being heard in London when it should be being heard in Texas? And this is why I said earlier, last week, private international in some ways isn't a close sibling of public international, or in some ways is, because this is an international world and you are going to upset the rest of the world if you try and treat yourself as some kind of resolution centre for the world. We mentioned this, I think, last week, but in any case, a number of you are probably familiar with the word. What's the word that we sometimes use for the concept of trying to maintain good relations with other countries and other courts? What is that concept called? I'm sure you have heard it. Sometimes called comity. And that is a concept that, it's no coincidence, is very widely used both in public and in private international law. And we could sit here for the rest of the academic year arguing about what exactly comity really means, and I can say a huge list on it. But for today, we could say it is the plain and simple argument that it's a world out there. There are other countries with their own priorities, and you have to make sure that you don't upset those other countries. Not least, going back to what I was saying about enforcement of judgments, if you start upsetting other countries, then they're just not going to enforce your judgments in possibly any cases, even ones where you did reasonably exercise jurisdiction. If you go ahead trampling on their toes, why should they help you? Why should they enforce your judgments? So as well as all these private law considerations, there definitely are public international law considerations at play. There are other things at play here as well. Again, go back to where we were at the start of today. If an English court, if you've got this kind of fact pattern where you could sue in more than one country, and the English judge is prepared to take jurisdiction even though the claim has got not much to do with London, what's there a very high risk of there being? elsewhere, what's the Texas judge likely to do? There's a very high risk of parallel proceeding, two sets of proceedings in different parts of the world. Parallel proceedings are incredibly wasteful because you're, by definition, the same or overlapping issues are being heard in two courts in two different parts of the world at the same time. Incredibly expensive. Futile in one sense, because you can't enforce two judgments. If the two judgments end up conflicting with each other, you can't enforce both of them. So only one of them is going to be ultimately capable of potentially being enforced. And again, it has all that cozy dimension. You're going to offset other leaders. The phenomenon of parallel proceedings you'll sometimes see referred to by a fancy Latin term. It's sometimes referred to as lis pendens, or sometimes even more complicatedly, lis alibi pendens, which really means the same thing. But whenever you see the reference to lis pendens, that is basically the phenomenon of parallel proceedings in two different jurisdictions on the same or related issue. Potential problem. Now, given all of these uncertainties, about forum, it's not surprising that many, many people in contractual disputes, doesn't really work in other areas of law, try and prevent uncertainties arising later on about where they should sue by doing what? What's a sensible tactic? By choosing a jurisdiction in their contract in the first place, and saying any dispute shall be heard exclusively, or whatever it may be, in the courts of London or the courts of New York. Back to first of all, what you said a few minutes ago. If you've got this kind of situation, and the English court says, yeah, sorry, that appalling diagram is supposed to be a contract with a clause in it saying any dispute is to be heard in the New York courts. Apologies for the diagram today, which will inevitably follow in the coming weeks. But that's not good about a contract that says any dispute is to be heard in the New York courts. If the claimant, particularly perhaps the defendant from New York, but anyway, comes to England, and the English claimant comes to the English court and says, I'd like to sue here, please. Do you think, how should the English judge react if the defendant turns around and says, well, hang on a minute, there's this contract here, and it says any dispute to be heard in the courts of New York? Do you think the judge should ignore the contract? Because his jurisdiction, he or she is sitting as a court of law, a public authority. And it's not for private parties to determine the boundaries of the authority of a public body. Do you think he or she should say, contracts are there to be enforced, that's my job, so I'm definitely not going to hear this case. I'm not going to, irrespective of whether I would be willing to hear it if there hadn't been this contraction clause, there is this contraction clause, so off you go. Or do you think the judge should be taking some kind of middle position, saying, for example, I probably won't hear it, but persuade me why I should? Do you think it's the right approach?
Follow the contract with the public policy concern.
Okay. So you're not very persuaded that it's a public body and you should be able to ask the jurisdiction of a public body by a private agreement?
I would argue that parties bargain before that agreement, and for expediency, they usually there's a bit of a go. For example, if a massive corporation have standard terms, say, well, we're here in New York because for some reason that's a better deal for me, like Amazon versus you as a consumer.
Yeah.
That's not a bargain.
Okay, and whether there is a bargain, a fair bargain, is not the same question, but an important question. Yeah.
Maybe the court should at least consider it until the contract is valid.
Okay, and I think you would agree with each other on that point, that is it really a clause? Perhaps even is it a fair contract term? If it's a stated or legal standard form that you can probably get to review. Let's keep it simple for the moment, assuming there's no doubt that the parties actually agreed it. Your inclination would be saying no discretion at all, just rubber stamp it and say I'm not going in that case.
I would say they generally allow the clause to proceed unless there are other clause reasons to action. For example, matters like bargaining power when there wasn't one agreement used that the IFC terms and conditions because you had no choice to take jurisdiction.
Okay.
Maybe you should hear the defendant for community consent, litigating it.
Yeah, maybe the defendant has decided that they don't want to rely on the clause anymore and they don't mind. That's true.
Doesn't that defeat the purpose of the document?
It does, but on the other hand, if you and I agree that any disputes are going to be heard in New York, and then you sue me in England anyway, and I say, yeah, okay. I suppose you could say that. If you like, that's like a variation of the contract. If we could agree to have New York, then we could agree not to have New York. You could say. Well, broadly speaking, the approach under the European regulation and the common law are very different. The regulation starting point is there are certain kinds of case where these clauses don't work at all, and you've already anticipated one of them, which is certain types of consumer contract and certain kinds of employment contract. But provided they do work, provided it's not one of those kind of contract with a weaker party like a consumer or an employee, then the court's just going to more or less just give a factor, and that's the job. They're not to say, well, I wonder whether I should do it. The English common law approach is pretty much the opposite of everything I've just said. There are no special protections for consumers. There are no special protections for employees. The judge, I'm no doubt that if I had to go to the English court to defend why I started a claim there for a claimant, then there's a New York jurisdiction court, I'd be dreading going into court and I know I'll get shouted at by the judge. So don't get me wrong. The judge will be commercial and the judge will start from a very strong instinct that he or she should not let you sue there at common law. But the judge will hear the defendant. The judge will hear the claimant. And the judge will let the claimant argue why, exceptionally, in the court's discretion, it should not give effect to that jurisdiction agreement. And it might be because it was an unfair bargain. That would come down to an element of discretion in the judge rather than any fixed rule. But it might be as simple as, look, judge, it doesn't make sense to have a trial in New York because, for example, absolutely all the witnesses are here, all the evidence is here. Can anyone think of any other reasons why the English judge might be willing to hear a case even though the parties chose another country? Sorry?
Dispute concerns a piece of land.
Yeah, something like if it concerns that ownership of a piece of land or something very literally part of the English territory, there may be very certain types of subject matter, a strong desire to not to let that sort of dispute about who owns a piece of land in London be heard in New York. I think the thing we mentioned a few minutes ago, lis pendens, if there are related proceedings already in London, for example, then an English judge may well be open to persuasion when it just doesn't make sense. All this related litigation has already taken place in London. Why hive off one bit of it, of the litigation, and send it to New York? It's just not expedient to do that. And another common reason a judge might not give effect to it is if there are lots of parties. So, for example, claimant and defendant, if I can use C and D for claimant and defendant, might have agreed this clause. But what if there are 10 defendants to the claim, and all the others are in England, and none of them have agreed to a jurisdiction claim? Suppose you've got 10 defendants. This defendant, we'll call that D1, for defendant 1, who's, if you like, got a contractual right only to have proceedings against it in New York. but what if you've got 10 other defendants, all of whom are based in England? You'll have no jurisdiction agreement with the claimant, and are clearly best served in being sued in England because it's most expedient they are based here. What's the problem if the English court gives effect to a jurisdiction clause between the claimant and the first defendant? But you then end up with, if they're all co-defendants, to say that it's conspiracy. Which would happen. We'll then end up with a conspiracy where 9 of the defendants are tried in London and one of them is sent packing to New York in relation to the same claim which they're all said to be liable. That doesn't necessarily seem like a good idea. There are different ways of dealing with jurisdiction agreements, and we'll be looking at jurisdiction clauses in some detail, both, well, not both, under the English common law discretionary approach, under the EU fixed approach, including the rules on consumers and weaker parties. And we'll be looking at how the US deals with the jurisdiction clauses, which is probably slightly different again to both of the other two approaches. Let's stay with that issue of weaker parties. Actually, let me go back to something I said a long time ago. First. I suggested to you, you may or may not want to agree with me, and that's fine, that in many ways the claimant holds most of the cards in international litigation because they can choose whether to sue and where to sue and when to sue. I think the European community agreed with that view because right from the very beginning in 1968, the Brussels Convention, the rules on the rules in the Brussels Convention, contained a central rule to which there are exceptions and derogations, yes, which is that litigation is about that. The claimant is in control. And an easy way of redressing that balance would be to have a general rule in that Brussels Convention, which survives to this day in its successor, the recast judgment regulation that applies today in the United Kingdom, at least at the moment, which is that defendants, as a general rule, should be sued in the member state where they are domiciled. And that is immediately a kind of protectionism for everybody, including companies and individuals. But because the claimant is in control of the matter, one way of redressing that imbalance is to say, well, normally you should sue where the defendant is domiciled. So that, for example, a claimant domiciled in, let's say, in Italy, normally, and there are lots of exceptions to it, normally has to sue the defendant in the defendant's home country. That's a kind of protectionism in its own right. As I said, the Brussels regulation recognises various exceptions to that. One of them is jurisdiction agreements. That if the parties mentioned into a jurisdiction agreement, then normally that should prevail over this rule. This rule should be swept away. And instead, if the parties agree to sue in, for example, the French court, then the English court can't hear the case, and the case should be heard in France. One of the things that the English common law never really wrestled with, and never has wrestled with, is whether you need completely different jurisdiction rules for vulnerable people or vulnerable groups. It's not individual, I mean at an individual level, consumers, employees, and so on and so forth. Now, these two principles that I've just stated, you should give effect to jurisdiction clauses. We all agree that's not particularly controversial as a starting point. And the general rule in the regulation is you should sue defendants where they are domiciled. Sound well and good. but they are significantly problematic if you're thinking about, for example, consumer. You talked about the example of clicking something on Amazon. We've all done it, bought something on the internet, and it says, I agree to the terms, click here if you want to view them, I don't want to do that. If you do actually need to fill in that curiosity, then screens are that. I agree. Take it or leave it. And probably right at the back of that huge document is a clause, is a jurisdiction clause. What's the problem in standard form agreements? Whether the consumer is at fault for not having read the terms or not, or clicking I agree, what's the jurisdiction clause almost always going to specify? A forum favourable to who? Sorry?
This is the seller of this house.
Yeah, it's more generally, yeah, outside the sale contract. Those kind of standard form contracts, the business is always going to choose either their home forum or some other forum that's very favourable to them or there, or somewhere where they think that the standards of regulation are lower. And so the European community started from the view this just won't do. There's got to be some special rules for weaker parties because jurisdiction clauses are. Consumer might say, I agree to them, but they have no real effective choice. And you might say, I don't know how many figures really to quote, but let's say 99% of cases where a consumer deals with a business, there is some kind of standard for jurisdiction clause, maybe 95% of cases. And it is not helpful to the consumer. But now imagine you're in the 5% of cases where there isn't a jurisdiction clause. How's the business? Then the default rule is you have to pursue the defendant under the regulation where the defendant is domiciled. We said that was a kind of protectionism, and it is. But when it's the consumer suing the business, the defendant domicile rule, which is what it's often called in the regulation, the general rule, doesn't look so good because what consequence does it have for the consumer when the consumer suing the business? They've got to sue the stronger parties for it, the businesses for it. So it's really like heads you lose. Heads you lose if there's a jurisdiction clause as a consumer because it's going to be against you. And if there isn't a jurisdiction clause, which is not very likely, you're going to lose anyway under the general rules because you're going to have to sue the business in the business's home country as opposed to domicile. So the EU set about it, I've already mentioned this, a completely different way to the English common law. It said, no, you need a set number of rules that are completely distinct for these so-called weaker parties. And we'll be looking at those in the course for consumers, for employees, in particular, insurance policyholders as well, although I won't look at those in detail in the course. A couple of other things to think about. I think I've already said to you, and it will do for today, as I said to you last week, there are two different legal systems in force in England, at least at the moment. The common law rules and the recast judgments regulation. And I'll say to you again, and if you rely on this advice when you're advising in practice, it's a different subject with insurers, I would say. But again, it will do for tonight. Very, very crudely, the regulation tends to apply if the defendant is domiciled somewhere in the European Union. With, in most cases, the claimant's domicile being absolutely irrelevant. So, for example, if the claimant is domiciled in China, but the defendant is domiciled in England, that will normally be a regulation case in England because the defendant is domiciled somewhere in the European Union. The common law is the exact opposite. So as soon as I flip those two around, and the claimant is from England and the defendant is from China, that will normally be a common law case in England because the defendant is domiciled outside of the European Union. And as I said to you last week, these two regimes are about as different to each other as it's possible to get in terms of conceptions of how to deal with the jurisdiction. So for several hundred years, until 1987, which I know sounds a long time ago, if you're thinking about a legal system that's been around for 7, 8 plus 100 years, is comparatively speaking very, very recent. Until 1987, this was the only legal system in town. There was only the common law rules of jurisdiction. They applied to everybody, regardless of what country they came from. And they are characterised, as I said last week, by a small number of rules. And then extensive judicial discretion. In other words, you can't sue in England unless you come within the rules. The limited rules that say, in this situation, an English court may hear a case. But in the English common law, the fact that an English judge may hear a case is just the beginning. It's stage 1, and you don't get to stage 2 unless the English court may hear the case under those limited rules. But if they can, then most of the argument is actually about stage 2, which is should the judge, in his or her discretion, hear the case. They can hear it, should they hear it? And there is a great deal of judicial discretion. And in particular, and I imagine you would have come across this if you weren't familiar with it already, if the claimant can show that there is a rule of jurisdiction that enables them to sue here, the burden normally then passes to the defendant to say to the judge, okay, I know you can hear this case, but you should not hear this case. But the initial burden tends to be on the claimant to show that they fall within one of the rules that are permits them. Okay? And then it's up to the defendant. The defendant can just say, fine, I give it. You can sue here. I'm not going to spend £300,000 arguing that. Or the defendant can say, well, actually, Judge, you shouldn't hear this. You could hear it, you shouldn't. And in particular, what the defendant will typically say is, you should not hear this case because the case should be heard somewhere else in the world. It's not good enough to say, you shouldn't hear this case, Judge, it's got nothing to do with London. What you're going to have to do as a defendant is say, you shouldn't hear this case because the case ought to be heard in Texas, or Brazil, or Ontario, or wherever it may be. And that plea that the English court could hear the case but shouldn't is often known by a Latin tag. What is that Latin tag? What is that plea? Yeah, that is known, and much more to come in the next few weeks, as the plea of forum non conveniens. But the forum, the choice, the court is not appropriate. They need to translate better as appropriate than convenient. And that's where the famous doctrine that we'll be looking at in 2 or 3 weeks' time comes from the plea that the judge could hear the case but should not hear it. Something about this you said a long time ago. You made a very good point when you said the defendant can always, if the claimant makes a bad choice of forum, the defendant will just argue, object to jurisdiction, and will win, and will get all their costs. All of which is true. But it's not a complete answer. Imagine that I start proceedings against you in England under the common law rules. It's very likely. You think that's completely outrageous. What's Harry's done? Why is he starting proceedings against you? It's quite obvious that this case belongs in whatever jurisdiction it might be, Argentina, let's say. What's going on? Outrageous. I'm massively confident that I could persuade an English judge, or I think I could persuade an English judge, let's say, that this case would be much better dealt with by a judge in Argentina. Okay. Great. So I start this day, I serve you with the documents. What do you do now? You're the defendant. Rip them up, put them in the bin, file them in the safe, put them under your mattress. What do you do with them? What do you have to do? Really? You have to do something with them.
Respond by challenging jurisdiction.
Either respond by challenging jurisdiction or respond and say, basically, you'll get more of this in weeks to come. You have to tick a box. If it's outside, if you've received the documents outside the UK, you'll usually get 28 days, and you'll have to tick the box. I intend to challenge jurisdiction. I do not intend to challenge jurisdiction. If you tick the box, I do not intend to challenge jurisdiction, then you'll go straight to trial in London. If you tick the box saying I do intend to challenge jurisdiction, then you'll have to do it. And you'll have to bring an application to challenge jurisdiction. You'll need to instruct lawyers in England. You'll need witness statements or affidavits. You'll need barristers to argue the case in court for you. You'll need skeleton arguments before the court. And you can then turn up and argue for or non-convenience. What if you lose? What if you lose? You were super confident that you didn't know much about the English legal system, you're pretty confident you could persuade the English judge to see sense that this case should be heard in Argentina, and you lose. Now what happens to you? Yeah.
I would like to have the case heard in the
Okay, and in the meantime, how much might you have spent?
You've lost the money.
Worse than you've lost the money. You've probably lost the money and you've paid everyone else's cost. Now, I'm not saying you won't succeed, but I am saying that I don't think saying, oh, well, the defendant can always challenge jurisdiction, myself, is as good an answer as it should be. Because the fault of almost any legal system, actually, but particularly the common law rules, is once the claimant starts their proceedings, even if actually they've taken them outrageously chosen in my decision, and they clearly should, the defendant's got to do something. And if the defendant doesn't tick any box, by the way, within 28 days, say I do intend or I don't intend to challenge jurisdiction, then it's as if they tick the box saying I don't intend to challenge jurisdiction, the judge just goes ahead. So the problem with forum non-convenience is it's a system that actually puts a lot of the onus on the poor defendant to make the jurisdiction challenge and stake a lot of money, a lot of time, a lot of costs, a lot of stress in challenging jurisdiction. Again, another reason why I personally think that the claimant does hold this for the cards in legal proceedings. But it is true to say that the defendant can sometimes fight back by challenging jurisdiction in England. And it's also true to say that the defendant can take other steps if the situation is exactly the opposite, and that they find themselves being sued, say, in Texas, where they really, nobody wants to be sued, but where they think, if I am going to be sued, I actually want to be sued in England. And partly because English courts are receptive to the idea that defendants shouldn't have to be completely passive and just take it. The English courts have, supposing you have this situation, the defendant's being sued in Texas, and thinks it's outrageous that they're being sued in Texas. They don't want to spend money in a Texas court challenging jurisdiction, or they've been advised they'll lose. It's a waste of money challenging jurisdiction in Texas because the Texan judge will hear almost anything. They might have been advised of that, and we'll form a view on that next term. What might that same defendant do in England? Somebody mentioned it. You may have mentioned it actually a while ago. What might that defendant do in England, or try to do? What's an anti-suit injunction?
Basically, when they're in another jurisdiction, they're basically trying to get that court to say, basically to halt the proceedings pending determination in the more appropriate forum. That would be
It's a pretty extraordinary thing when you first see an anti-suit injunction. And then if I'm being sued, I'm being sued in Texas. Confusingly, I'm the defendant in Texas. I'm outraged by it. I don't want to go to Texas and argue they've got no jurisdiction because I'm going to lose, or why should I spend the money? Or maybe I did go there and argue that and I lost. An antecedent injunction is, if you seek one of those, is the person who's being sued or threatening to be sued over there coming to London and saying to the judge, these proceedings in Texas, to keep this example, are outrageous, should never have been brought there. I want an injunction ordering C not to continue with those proceedings in Texas. Another example of how English law has always recognised the idea that defendants aren't completely passive. They're not passive if they're sued in England and they don't like it, but nor are they completely passive and helpless if they're sued in a foreign court and they think they should be sued in England. So, and we'll talk about antecedent injunctions in a few weeks' time. The way an English lawyer would defend antecedent injunctions is that they are a prompt and effective way of stopping claimants from undertaking abusive litigation abroad. Including litigation, by the way, that might be in breach of an English choice of jurisdiction. That's the way an English judge would justify it. I'm stopping abusive litigation overseas quickly, and I'm helping the poor defendant, who's very passive otherwise, has to wait to be sued. I'm going to help them. But as I said to you earlier today, private international really has a public and a private dimension. How do you think, whether you know or not, as a general rule of thumb, how do you think courts in foreign countries react when a judge in London, that judge in Texas presumably thinks he or she is perfectly entitled to hear the case, and then finds out that a judge in London has ordered the claimant not to continue with that case in Texas? How do you think they go down on the world stage? Have a guess. Not well, because they are sort of the arch enemy of comity in that sense, aren't they? Because you're reaching out and saying you shouldn't be sued in that foreign court, and in principle you're criticising the foreign judge for hearing that case. Antecedent judges, I think, are one of those interesting things we look at, because different people, depending on which end of the stick you pick up, would think that they are a very effective way of dishing out fair and swift justice to a defendant who otherwise just has to accept everything. He can't do anything actively. And those that think that they are just a complete outrage. Yeah.
Can the antecedent injunction be brought before the claimant exists?
That's a good question, and more detail to follow in a few weeks' time. Yes, but if you go to an English court and the English court is not convinced that those proceedings are going to happen imminently, then the judge will probably say, well, you're paranoid, or I don't, it's too early. One of the things I'm talking to you about, one of the things you never see in the books very much, is how to get your timing right. Too late. The proceedings have been going for a year in Texas, and you say, by the way, it's not going well. And see a judge the judge will say, well, come on. Everyone spent $200,000 or $500,000 now, it's too late. You have got to get your timing right. It's good. So we'll be talking about, in a few weeks to come, how the defendant fights back, whether a defendant can take control of the proceedings in an English court. But the other really fun thing, I'm running out of time today, but is in a discretion. So the thing that I hadn't completed, although I did say it last week, is that the regulation is pretty much everything is exactly the opposite of that. It's very detailed rules of jurisdiction and little or no discretion. The regulation is much more like a manual. It says if this happens, then you can hear the case. If that happens, then you can't hear the case. And stage 2, I can hear the case, but should I? It virtually doesn't exist. Okay, there are some exceptions to that, but it virtually doesn't exist. And so when, in 1987, but that's when it first was, the European rules in the original Brussels Convention came into force, it was like a metaphorical earthquake. Because what the English courts have been doing for the last 700 years or what have you, with this highly discretionary system for the whole world, suddenly had to sit alongside, for defendants domiciled in England or the EU, a regime that couldn't really be more different if it tried. Now, with due respect to our judiciary, the legal system in England is not one where you train to be a judge at a young age. You tend to work your way through the legal system, and then if you want to become a judge and you're successful, you apply to become a judge at typically a reasonably senior age, let's put it that way. There are still many, or most judges in England in the senior courts who grew up with the common law and only the common law, and have had difficulty accepting or even in some cases believing that the European rules fetter their discretion and their power to do things, to give up jurisdiction, because it seems to them obvious that the regulation might say the defendant's domiciled in England, you could hear the case, but they think it's obvious that the case should be heard in Argentina or Brazil, and have read in all sorts of residual powers to exercise their discretion until the European Court of Justice in Luxembourg said absolutely not, you cannot do that. It seemed obvious to an English judges for 20 years nearly that they could carry on issuing anti-suit injunctions if someone was suing in Spain in breach, what they thought were obvious breach of the rules of the regulation. Until the ACJ said, that's outrageous, you can't do that. We all love and respect each other in the European Union. You can't start letting out anti-suit injunctions at the Spanish judge. Let the Spanish judge make their own interpretation of the rules of the regulation. You cannot be so arrogant sitting in London as to say the Spanish judge is getting it wrong. Nor can you say we'll deal with it quicker. No, if the proceedings have been started there, then the Spanish judge will decide. So what you have is this really interesting subject where there's two legal systems that collide and have sat for the last 31 years very tensely with each other in the English legal system. It's also one of the most interesting parts of understanding as we go through the course, and of course it's more complicated than I described, how the two regimes fit together. The other thing I perhaps should mention, just for the sake of completeness, although I'm going to come back to it in a minute, is that as well as the European rules of jurisdiction applicable across the whole EU, there are very similar rules that exist between all of the EU countries on the one hand, and 3 other countries that are not in the EU but are in the so-called European Free Trade Association. And those countries are Norway, Iceland, possibly in commercial terms the most important, Switzerland. So as well as the regulation rules, there is also a convention on jurisdiction between all of the EU countries on the one hand, and Norway, Iceland and Switzerland on the other. And although it's not identical, that convention contains very similar rules on jurisdiction and enforcement of judgments to the recast judgments regulation. I think someone said it. What's that convention called? It's called the Lugano Convention. There is also this convention between the EU countries, including the UK, and Norway, Iceland, and Switzerland, harmonising the rules of jurisdiction and enforcement of judgments, called the Lugano Convention. I'll come back to that in a minute. The course is not going to go into detail on the Lugano Convention, not least, partly because there are only so many hours in the course, but more importantly because 90% of the rules are the same as in the judgments regulation, and I will tell you if there's an important difference. Come back to that. I suppose I should say something in the last few minutes of today about the B word, Brexit. But before I do, I'm just going to... We've talked a lot about jurisdiction today, and that's right, because jurisdiction is the huge, colossal subject, and enforcement of foreign judgments is a much narrower subject. But I think we should say something about enforcement of judgments, foreign judgments, for perhaps 10 minutes, and then perhaps 10 minutes on Brexit. Firstly, with the obvious point, I mean, we've already been talking about this, so I think it's pretty obvious, but why might you need to enforce a foreign judgment in England? You get a judgment from a foreign court. Let's take 2 examples. One is a Texan court, and the other one is, let's say, a Spanish court. Why might you need to get that judgment recognised and enforced in England?
If they are
Okay. The most obvious reason is the one you've just given. The defendant doesn't have enough assets in the foreign country, won't pay, and doesn't have enough assets to satisfy the judgment. You can't just turn up in England with a Texan judgment and start seizing assets or freezing assets. You have to go to the English court and get the English court to recognise and enforce any judgment. What does it mean, recognise and enforce a judgment? What does recognise? And actually, I'm about to say what does recognise the judgment? Yeah.
I think it's to avoid the same level of tendency to the deployment of the other.
It is exactly that. So effectively, to say that it's brought into the English legal system and regarded as conclusive. Conclusive in one particular sense, because there are cases where all you ever need is recognition. Supposing I sued you in Texas, and I was after £10 million of damages against you. I won, but I didn't like the result. The judge only awarded me $2,000, basically said this is a claim that technically you're right, but you should never report this claim, and your losses were greatly exaggerated, Harris. You should, I'm going to give you $2,000. So I say, I actually don't want to enforce that judgment against you in court. I'm going to sue you all over again. I'm going to pretend that never happened, and I'm going to sue you again. And I issue a claim for another with exactly the same claim pleaded out against you in Texas. We tend to think about claimants wanting to get judgments recognised in England. But what if you as the defendant, going to want to say about that Texas judgment? Yeah, go on, sorry. Yeah. You're going to say, go on.
It has already been tried.
Yeah, it's entitled to recognition. It is conclusive as to the question of liability between the parties. Somebody mentioned a Latin term. Yeah. The concept which exists in domestic law as well, sometimes when you talk about a judgment being recognised, again, lots of Latin terms are bandied about. Some are described as res judicata. All that means is a thing that has been decided. That's just a fancy way of saying the foreign judgment is recognised in England, it's conclusive as to the liability. One of the things that means is you can't sue again on the same thing. That's what recognition really means, the liability. Enforcement is about getting the money, or getting the remedy. Okay? And usually, you need both. You can't have one without the other. First, the judgment is brought into the legal system, as you say, then you enforce it, and then you say, okay, now I want to take steps to get the money, I want an order disclosing the defendant's assets are at necessary appointed bailiffs to go and seize the property. All of those kind of things you could only get if the judgment is enforceable. Why should an English court enforce any judgments of any other country in the world?
So other countries enforce theirs.
That's a pretty simple but pretty effective answer, and it's probably number one on the list, isn't it? In a way, partly that's just pure pragmatism. Okay? If you don't enforce our judgments, then nobody's going to enforce yours. And talk about destroying legal services in London, that's going to be, if English judgments aren't worth the paper they're written on, unless all the assets are legally stored away in London, which with wealthy defendants are very unlikely to be, then they're not going to enforce your judgment, and it's a self-defeating work.
That's what we do.
Well, exactly that. That's a private law one, but it's also, or a pragmatic one, but it's also a penalty one, isn't it? It's a disaster for international relations. If a case perfectly properly belonged in Texas, why should you not give a fact to it on the international stage? It's also an international trade point. For English sellers to the rest of the world and foreign sellers to England, they want to have the confidence that if they do are owed money, that they can effectively collect those debts. If they deal with an English buyer, or an Argentinian company, and you're selling your products to an English buyer, you want to know that if you export your products to the world into the United Kingdom, that if the buyer doesn't pay, the English courts will help you. you get a judgment from an Argentinian court, will help you to recover your money. Otherwise, you may think, well, but that's part of the world I don't particularly want to trade in. I don't want to offer my services in that country. And let me say this. The Brussels Convention of 1968 that I mentioned some while ago, nobody started out saying, well, actually, although I said it's a good idea, nobody started out saying, wouldn't it be a great thing to have the same rules of jurisdiction in France and Italy and Germany and so forth? Nobody said that. What they said is, the European Union is all about free movement, in those days really just of goods. Free movement of goods. There must be no disincentive for the French, for example, the French farmer must think that they have as much of an incentive to trade with the German buyer as they do with the French market. How do we do that? We have a free market in judgments. In other words, free movement of judgments around Europe was considered to be sort of a necessary element of having free movement of goods at all in the European Union. That you have to remove disincentives for European sellers and service providers to provide their goods to people elsewhere in the EU. How do you do that? Well, if the European seller knows that if the French buyer doesn't pay, they'll be able to go up, they'll be able to present their French judgment in Italy. Then you've got an incentive, or you remove a disincentive, I should put it that way, to go into the free market. The real reason why the Brussels Convention of 1968, now the recast judgments regulation, ever existed in the first place wasn't about harmonising the rules of jurisdiction. It was to have free circulation of judgments. But one was a means to the other. The view was, if we harmonise the rules of jurisdiction, if we've all got the same rules, then when the Italian judge is asked to enforce the French judgment, the Italian judge should not reach the conclusion. It's completely outrageous that that French court took that case, applied rules of jurisdiction and heard that case, because they're exactly the same rules that apply in Italy. They're by definition shared, acceptable rules. So if you like, having common rules of jurisdiction was the means of removing the objection that that court should never have heard the case, was the means of promoting free trade and free movement of judgments. Why shouldn't we recognise that if free movement of judgments, whether in the EU or not, is a good thing, why shouldn't we recognise all of them? What kind of objections might an English court have to attacks and judgments then?
If that the law that was decided on has no equivalent in English jurisdiction.
Okay. There may be public policy reasons. You know, the law has no equivalent, or it's a contract that, for example, an example is often given. There was a contract for the supply of cannabis in a legal system where buying so cannabis is legal, and there's a damages award of $5 million. An English court's probably not going to do that for public policy grounds, if nothing else. There are public policy grounds. What else? What do we know from talking earlier today? What do Texan courts like to give? Okay. Punitive damage or US antitrust law. Again, it's a similar kind of point, but slightly different. Often an English court will be offended by the idea that punitive damages awards, particularly if they're payable to the United States or to a government, should be enforceable in England. Then the really, and one of the things I perhaps should have said earlier when we talked about the common law rules of jurisdiction, you get the same problem in the common law jurisdiction rules as you do with enforcement of judgments, is when you have a judicial discretion, is you may simply feel that the procedures of the foreign court were not adequate or fair, that the defendant didn't get a fair trial, or didn't get a sufficient right to defend themselves. And an English court may be drawn into some very sensitive questions in relation to courts in some parts of the world about whether there was a fair trial at all. To give you a flavour of that, one of the very interesting questions that we will look at next term is in the European countries. I'm sure you all know that there's the European Convention on Human Rights, which says that everybody has a right to a fair trial. It's pretty obvious that that has to be applied within the European Union. But a very interesting question we'll look at next term is, supposing that the trial took place outside the European Union, in a non-EU country. If an English court is asked to enforce that judgment and thinks that there hasn't been a fair trial, does the English court have to apply the standards of Article 6 of the European Convention of Human Rights to that judgment on the basis that if it's going to, as you say, bring it into the English legal system, it can't possibly entertain bringing a judgment, even from a non-EU country, into the English legal system, if that judgment is one where the defendant didn't have a fair trial, because then the English court would itself be breaching the European Convention of Human Rights by receiving a judgment that was not from a process that was not fair. All of these are issues about why an English court might not enforce a judgment, but none of them is the main one. The main one is the one we started with today, the one that the judgments regulation tries to get rid of, which is that the English court does not think that the courts of a non-EU country ought to have exercised jurisdiction in the first place. And that takes you back to where we started today. Outside the EU, we all have our own rules of jurisdiction. And we will all have a view about not just whether we should be taking jurisdiction, but about whether a foreign court should be taking jurisdiction. And the single biggest obstacle outside the EU to free circulation of judgments is widely different views about whether a foreign court should have heard a case in the first place. And I think you'll be amazed when you look at foreign judgments next term about how polarised the law is. I mean, basically, and again simplifying hugely, if a judgment comes from somewhere else in the EU, or in what I call a Lugano country, so Norway, Iceland or Switzerland, the rules on when they are enforceable in England are massively liberal, and vice versa. English judgments are very easy to enforce in the rest of the European Union. Almost the exact opposite is true for judgments from anywhere else in the world. I think you'll be shocked if you've never seen it before, how few judgments from the rest of the world, including the US, are actually enforceable. The rules are almost equally as restrictive. I said I'd finish with something about the B word, Brexit, and this is the reason why well, there's several reasons, but there's one big reason why I'm finishing with this. It's possible that as of the 29th of March 2019, there'll be no agreement for a transition or deal or any kind of deal with the European Union. We might know that in the next few weeks if it happens. And the UK will fall off the metaphorical cliff, and the judgments regulation will simply stop applying in the United Kingdom. That isn't necessarily the end of the story, because there is still a question which I can't give you an answer to either at the moment about whether the Lugano Convention will continue to apply in some shape or form. But it is obviously a possibility. I think more likely, as I said to you last week, is that there will be, and it's already outlined, it's one of the few things that has been agreed, as provided that there is a withdrawal agreement at all, that the existing rules will carry on till the 31st of December 2020, the end of the transitional period that's proposed, and during that time we're trying to work out what the long-term situation will be after that. I still think personally, although I shouldn't be making predictions really, that is more likely to be what happens in the end, which is... Now you might say, if you've been following the English position, or the UK position I should say, closely, that all of this is so much hysteria. Because one of the things the government, the United Kingdom government, said very early on was that to prevent the metaphorical cliff face, if there is no deal, the United Kingdom is going to enact the entirety of European law into English law. So basically, there will be a statute that says basically all European law as applied in the UK on the 29th of March 2019 shall continue to apply in the United Kingdom. And you've probably heard of that legislation, the EU Withdrawal Act, that has been concluded. So you might say, well, who cares? Whatever happens, one way or another, the recast judgments regulation will carry on applying in the United Kingdom after the 29th of March, even if it's just because of the EU Withdrawal Act and the UK saying, well, we're going to carry on applying it. But there is one massive problem, which means that the EU Withdrawal Act doesn't work. And it's obvious when you think about it. If the United Kingdom were to simply say, deal or no deal, forever for the future, I'm talking about not just up to the end of 2020, but long term, we're going to carry on applying the recast judgments regulation in the United Kingdom. It could do that. And it would carry on freely enforcing judgments from France and Spain and Italy and Germany and Slovakia and it would carry on many countries freely. Because the UK can enact whatever laws it wants. If it wants to copy EU laws, who could stop it? There's one fatal flaw with that. If UK law does that, but there is no deal with the EU in the future, what will happen when you get an English judgment when it's the other way around and you try and present that for enforcement in France or Germany or Italy or Spain? What will they say? Yes. So you're not a party to at an international level, you're not a party to this regulation anymore, you're not in the EU anymore. Sorry, we're not enforcing your judgments. And if you think about it, it's obvious. If there's no deal between the EU